morning and welcome to the Court of Appeals. We have two cases on the 9 o'clock docket, both set for 15 minutes per side. I see counsel are set up in our first case. Does either of you have any questions concerning our procedures? Been here before. All right, then we're ready for argument in the Patten case. And just a word to our spectators, if any of you has a cell phone or similar device, would you please turn it off so that the attorneys are not interrupted during the argument.
Good morning. May it please the court. My name is Jeff Anderson, registration number 14907, and I'm with the firm of Sweetbaum Sands Anderson. I represent the plaintiffs and appellants in this case. As I'm sure the panel knows from reading the briefs, this is the second trip to the Court of Appeals for this particular case. We're here today on an appeal from the appellants from the trial court's decision after remand from this court the first time around. Now, before getting into the nitty-gritty, I'd like to take a look at the big picture for just a few seconds. This is a case about private property rights. Here, the unrebutted evidence is that the lake, that's the center of contention here, enhanced the value of the plaintiff's properties by over $1 million. Now, was that simply an illusion? I don't think so. The plaintiffs all testified that they paid a premium for their properties because of the lake. And then the defendants took that lake away out of spite. And there's no remedy. There's no consequence to the defendants. You know, our entire society is based on private property rights and the court system's enforcement of those rights. And yet over $1 million in value has vanished, apparently with no recourse. Now we're here today to talk about the nuisance claim. This was a fallback claim of ours all along. Water has special rules in Colorado, and before the trial, when the case was just getting started, we were worried that the trial court might not have the authority or the desire to require the refilling of the lake. Now, that's what the plaintiffs wanted, but in case the court didn't want to do that, we had the fallback plan. All the plaintiffs testified to the diminution in value of their properties caused by the disappearance of the lake. That's why we asserted the nuisance claim. We told the trial judge if she ordered restoration of the lake, she could dismiss the claims for monetary damages. In fact, she ordered restoration of the lake, and so she dismissed the monetary damages claims without prejudice. So that brings us to lack of jurisdiction on the first appeal.
Somewhere in your argument, please tell us what position you took on the nuisance claim in the prior appeal.
Well, in the prior appeal, you know, we made a mistake. I think everybody made a mistake about the nuisance claim in the prior appeal. We argued the nuisance claim. That was a mistake on my part. The defendants argued the nuisance claim. And the court, in the majority opinion, also discussed the nuisance claim. But I think the reason that was a mistake is because there was no jurisdiction for this court to hear that. And the reason there was no jurisdiction is because the trial court had dismissed that claim without prejudice. And so when a court does that, when a trial court does that, it makes that particular claim not final and therefore not appealable.
But in reading the trial court's order, the order that was appealed, the trial court specifically said that there was a nuisance. So the court ruled on it. It wasn't that it dismissed it, it recognized it, which was subsequently reversed.
The court did have some discussion of nuisance, but there were no final conclusions of law in that, so it wasn't completed. And I'll cite the case of Brody versus Bach. This is one that appears in our briefs. That's a Colorado Supreme Court case from 1995. That's at 897 Pacific 2nd, page 769. And in that case, the Supreme Court said that a final judgment is a jurisdictional prerequisite to review on appeal. Now, there's another case that we cited, this one from the Court of Appeals. It's called Seafried versus Hummel. That's a Colorado Court of Appeals case from 2005. And that one's at 148 Pacific 3rd, page 184. and there the court said, the ruling dismissing the fraud claim was without prejudice and therefore did not constitute a final judgment. Thus, it's not reviewable on appeal. So that, I think, is the threshold issue today, frankly, that the nuisance claim was not fully adjudicated below. It was dismissed without prejudice, and therefore this court did not have jurisdiction to hear it.
Does the phrase, which you've used several times, dismissed without prejudice, specifically appear in the lower court's order as applied to the nuisance claim?
Yes, Your Honor, it does on page 55 of the trial court's original order. The
Counsel, how do you reconcile the findings the trial court made concerning nuisance, where it appears to find and says that you sustained your nuisance claim? How do you reconcile that with the language, the claim is dismissed, if the court's already found that you've sustained it?
Well, we couldn't get both. The plaintiffs were not entitled to both having the lake back and having the damages. The nuisance claim, the monetary damages claim, there were several monetary damages claims. The nuisance claim is the one that makes the most sense at this point. That was just a fallback plan. And the reason we asked the trial court for dismissal without prejudice, if the trial court found that the lake should be returned, is because we couldn't have both. So again, it was a fallback. If the lake couldn't be restored, if this court or another court ruled that the lake couldn't come back, then the plaintiffs should then be able to get their loss of value. As I said when I started, $1 million has evaporated here along with the lake. No recourse for that. The majority decision, majority opinion in the prior case didn't really analyze the nuisance claim. In fact, the majority opinion at page 17 says, based upon our conclusion that refilling the lake was a remedy beyond the reach of the trial court, the remaining issues need not be reached. And so, as for additional discussion after that, that's a classic example of dicta.
But then they also say at the end of that same paragraph, we therefore dismiss those remaining claims on appeal. So what legal effect does that have?
Well, because the court didn't have jurisdiction to hear the nuisance claim, and it had already been dismissed without prejudice, it remained in the trial court for us to go back and pick up again because of the result of the first decision by this court, which is exactly what we had planned and why we had asserted the nuisance claim in the first place, so that we would have that fallback. Now, you'll notice that there is no discussion in the majority's opinion about exactly how or why the nuisance claim ought to be dismissed. The trial court found that draining the lake,
In that
I'm sorry?
same paragraph, the court says, compliance with the lawful order of the Division of Water Resources does not, in our view, constitute a nuisance. And we have found no law suggesting it is. Isn't that addressing the nuisance claim?
Well, that's just a skeletal statement, frankly, Your Honor. There's no discussion of what the basis for the review was. Was it a preponderance of the evidence, abuse of discretion by the trial court judge? Was it a de novo review by the court? And what is the law that the court relied on? I mean, the trial court...
Isn't that then the law of the case?
Well, not if there's no jurisdiction.
Well, yeah, I understand that argument, but this is a different question.
It's technically law of the case, but I think that because there's no jurisdiction, it doesn't count. Also, this court, this panel today, has the opportunity to revisit that if it so desires. The case of Taylor Morrison of Colorado versus Terracon Consultants, a case cited by both the plaintiffs and the defendants here. That's a Colorado Court of Appeals case from 2017. That's at 17CA0694. That says that this court can review an opinion of another panel in the same case where the previous decision is no longer sound because of changed conditions or law or legal or factual error, or if the prior decision would result in manifest injustice. Now,
Would that be would doing so be a matter of our discretion?
I believe so, that's right. Now, the trial court found that the defendant's draining of the lake was not reasonable under the circumstances. Now, that's something that you see no discussion of in the majority's opinion in the prior appeal. The trial court also found that defendants could have just as easily drained Tabor Lake, made the repairs, and refilled Tabor Lake. There's no discussion of that in the majority's opinion in the prior case. So, again, was that an abuse of discretion, erroneous as a matter of law? There's nothing in there about that.
And you filed for cert, did you not?
Yes, we did.
In your cert petition, did you raise any of these issues?
Um,
I mean, primarily the alleged lack of jurisdiction.
Frankly, I can't recall if we raised
Sure.
the alleged lack of jurisdiction, but jurisdiction is fundamental. That can be raised at any time. And so the fact that the parties argued it before or did not raise it in the cert petition does not preclude us from raising jurisdiction right now, because if this court did not have jurisdiction to rule on the nuisance claim, then there's simply no jurisdiction, and that claim cannot proceed.
Would a lack of jurisdiction, as you frame it, be subject to judicial estoppel based on the position you took?
Not at all. No.
So judicial estoppel is irrelevant to a jurisdictional issue?
Exactly. If the court doesn't have jurisdiction, there's nothing that any of us can do that's going to get it jurisdiction otherwise. Now, there's also the issue of the easements. This was another issue that was not ruled upon by the majority in the prior case. And the question here is, if an easement falls in the forest and there's not a judge around to hear it, does it still create a valid property right? And the answer is yes. And that's not just me talking.
But
That's the
there
Colorado
was a
Supreme Court.
judge that
Pardon me?
ruled upon it, but there was a judge that ruled upon the easement claims. I mean, the trial court gave a very detailed order addressing every single claim for relief. Claim 12, 13, 14.
Right.
Do those mean nothing?
Well, the Court of Appeals majority decision addressed it in about one or two sentences with a fundamental legal error. And that, again, appears on page 17 of the majority's opinion in the prior appeal. It says, "Thus we remain convinced that a valid order of the water engineer can preempt at least undeclared rights." Now, we cited the Supreme Court case, Colorado Supreme Court case of Spring Valley Estates versus Cunningham. That's a 1973 Supreme Court opinion, 510 Pacific 2nd, page 336. That said that in the adverse possession context, a property interest matures into absolute fee ownership after the statutory period. So there does not need to be a judicial determination of an easement that has otherwise arisen for it to be a valid property right. And that's what we have here. And that's where the prior opinion made the mistake of saying, well, it's hasn't been adjudicated, so it can go away without consequence. That decision made $1 million evaporate in the value of the plaintiff's properties here. And that's a decision that this panel can review under that Taylor Morrison versus Terracon case that I mentioned.
What in the prior appeal, what position did you take on the easement claims?
Well, we took the position that the trial court was correct on the easement claims.
Okay, and you lost.
That's right. But because of an error of law by the majority in the prior opinion. And that's what we're respectfully asking this panel to revisit. I encourage the panel to read Spring Valley and then compare that to the majority opinion on page 17. Now I have a little over a minute left. Are there any other questions I can answer? All right, well, I'd like to reserve my last minute and a half for rebuttal. Thank you very much.
May it please the court, Lance Goff, appearing on behalf of the Hollands. Mr. Anderson talks about this case involving private property rights and the alleged loss of $1 million of value due to the court's decision in the first appeal. And it is worth noting that the plaintiffs have no contractual right to compel the Hollands to store a lake from them. They have no deeded interest in compelling the Hollands to store a lake for them, and they have no water right allowing them to use or administer any of the state of Colorado's water. So this whole alleged loss is based on nothing. They have no rights, and they essentially attempted to invent a right by claiming they had been using the Hollands property for a number of years. The Water Division got involved when the dispute arose, and the order that was issued by the water engineer then was issued with respect to this being essentially a wildcat impoundment, and that this water was being held without a decreed water right or water storage right, and the division gave the Hollands 3 choices to comply with their directive with respect to them storing water out of priority. The Hollands complied with one of those 3 options, and they are in compliance with the state engineer's order as of today.
Counsel, what is your client's position about the legal effect of the trial court's order vis-a-vis the damages claims? At page 55 of the January 2014 order,
Yes.
it purports to dismiss claims for monetary damages without prejudice. What does that mean, and what's its legal effect, if any?
Your Honor, I think when you review that opinion, first of all, that language with respect to the dismissal of claims without prejudice is under the heading of damages. So in other words, the court's already addressed the issues of liability above. And under that heading of damages, she's then saying, okay, here's the so what I'm going to do here is I am going to, what she really was saying is that she was reserving ruling on the damages claim because that was not the preferred remedy that the plaintiffs sought. The plaintiffs wanted an injunction to compel the Hollands to refill the lake. And that was the relief that the trial court gave them. And so in the event that the Hollands would have disobeyed, for example, her order to refill, there was the kind of the hammer, if you will, hanging over them that she could award damages if they disobeyed her. There would be other remedies, of course, for disobeying the court, but that could certainly be one of them. So that's how I interpret that provision is nothing more than a reservation of a remedy.
And what's your client response to this whole claim that there was no finality, I guess, to the nuisance claim and the easement claim?
There was a what, Your Honor? I'm sorry?
I'm assuming that, I read their objection to lack of jurisdiction to be that there was no final order, no final judgment on the nuisance and easement claims. So what's your response to that?
Well, Your Honor, I don't think that's even remotely supported by the record. When you look at even our Rule 59 motion that we filed in the case, we asked the judge, the trial court, to revisit the determination that the Hollands had committed a nuisance by complying with the division's order. And Judge Hoke denied that request and sustained, essentially upheld, right, through Rule 59, her previous determination that the Hollands had committed a nuisance. So this whole revisionist history, frankly, that you're getting from the plaintiffs about how they made a mistake and how we made a mistake and how everybody made a mistake, it just doesn't, to me, ring remotely true. They defended the court's determination that the Hollands had committed a nuisance. And it was only after they lost, not only lost before the division, but lost before the Colorado Supreme Court on their cert petition, which has upheld the majority opinion that Mr. Anderson is attacking here today. That they had an opportunity, if they felt that the division made a mistake, to have the Supreme Court look at it, and the Supreme Court declined to do so. It's not appropriate now to come back on a second appeal. It's essentially asking this court to sit as the Colorado Supreme Court in that case. And so we don't think that's appropriate here. And that whole position that the claim was dismissed only came about on remand. That's super late in the game to be unearthing an argument like that. And I think judicial estoppel does come to bear in this, because they should not be permitted to take two contradictory positions in the same case when it suits when it's to their advantage to do so, given where the case is postured. That is exactly the reason that judicial estoppel exists, is to prevent this.
Isn't the question of judicial estoppel as applying to jurisdiction a really very different question than judicial estoppel in other areas? If we have jurisdiction, we have jurisdiction. If we don't, we don't.
I think that's true, Your Honor. I guess it just, to me, maybe it goes to the issue of their good faith or lack of good faith in conducting the post-remand litigation that they've undertaken, where they've essentially directly contradicted themselves to try to advance a claim that they're entitled to affirmative relief on remand on a case that they lost. To me, that's astonishing.
Do you recall what position they took in their cert petition, if any, on either the nuisance claim or the easement claim?
I don't have a specific memory,
Okay.
but I don't have a specific memory. So we believe that the nuisance claim was addressed by the majority, was properly before the court, because the issue of whether the trial court's determination that the Hollands committed a nuisance was appealed by the Hollands, and it was considered by a division of this court, and it was ruled upon by a division of this court, and the majority determined that the Hollands, by draining the lake, did not commit a nuisance. The division also held that the agreement to maintain dam and pond had expired when the Aspen Pine Estates subdivision was completed. So what we have after the majority's ruling is there never was a deeded right, no contractual obligation, and no tort. So there's no basis. There's no liability. The Hollands have no liability after the division enters its order and remands with directions to award costs to the Hollands. So how, in the absence of liability, could they ever be entitled to an award of damages? There has to be a claim, right? And there is no claim. Nothing survived. That's why the Court of Appeals, why the remand order is fairly simple and straightforward. And the trial court followed it to the best of her ability and pointed out that if she was to follow or grant their motion, that she would be undermining the court, not bringing about not following its directive, right, but undermining it. And she refused to do that. And that refusal has now been appealed to this division. And to me, it's not even a close question. And in fact, I think that this has gone on way too long, and that this appeal is frivolous as filed. They are re-litigating. They are seeking to re-litigate settled issues. The issue was settled, and that yet they persist in litigation. And that's why we are asking the panel to consider awarding the Hollands their attorney's fees and having to defend this second appeal. The only aspect, we did file a cross appeal after they filed the second appeal on the issue of costs. Judge Hoke did award the Hollands some of their costs and denied other costs. The one aspect of the cost order that we've asked the panel here to give a closer look at specifically is this part of the cost award, or cost request by the Hollands, in which they had to pay about an extra $20,000 on their mortgage because the plaintiffs decided when they brought this lawsuit to not only sue the Hollands, but they sued their mortgage lender. And the
Counsel, can
Yes.
you, and getting to that specific itemization or item of cost, I can see that the mortgagor and the mortgagee have a contract, and there's probably a provision, requiring payment of costs in that contract, but how does that then require a third party to pay those? Like, I don't understand what the basis for the attorney's fee award would be in that situation. It's a third party that's not a member or a party to that original contract.
So you're right that there isn't any privity, right, between
Right.
the plaintiffs and the Hollands mortgage lender. I guess the question becomes, when you, as a plaintiff, sue another party, in this case, a bank, and then the bank shifts part of their costs in defending that case onto the party who wins the case, right? And then the question then is, does that become, that, as a matter of fact, I don't think there's really any dispute that the Hollands incurred this cost to their mortgage lender of roughly $20,000, and it's in the letter that the mortgage lender provided when we filed our amended bill of costs. They incurred that cost as a direct consequence of the plaintiff's decision to sue them and their bank, and then the bank shifts their costs onto the Hollands. And what we're saying is that as between the two parties, right, the Hollands and the plaintiffs, who under the rules should bear that cost? The Hollands shouldn't. They didn't incur it.
I guess my problem with that is, it isn't, you aptly try to keep characterizing it a cost. But I mean, it isn't a cost of the litigation in the traditional sense. It seems to me, if anything, it's more like damages. For example, you see cases where there's a improperly filed lis pendens and somebody loses their financing or they lose the opportunity to sell the property. And that can be litigated, but it's a damage claim. It isn't a cost shifting.
You could be right. I guess maybe my argument is being animated more from equitable principles that, here our clients got dragged into this case. They ended up having to pay these funds. They had really no choice in the matter, right? It's kind of, you go out to get a payoff on your mortgage, and the mortgage lender gives their payoff number, and they included that as a line item to basically make the Hollands pay for their attorney's fees in defending this case that the Hollands won. And so, I understand if the panel takes a different view, but it was that aspect of the cost award that we wanted you to take a closer look, and if you look at it and agree with the judge, then we understand.
Guess, how did you present it in the trial court? As a cost or as an attorney fee?
I believe we did as a cost because they weren't our fees, right? We just got a number from them, and that's what we ended up having to pay. So I do believe, Your Honor, that we conceptualized it as a cost that the Hollands ended up absorbing as a result of this litigation. Anything else from the panel? Thank you.
I think with respect to the nuisance claim and Mr. Goff's statement that the Hollands have no liability here, it's important to keep in mind that the nuisance claim is based on the fact that there was actually water on the properties of most of the plaintiffs, and it was the taking of that water off that the trial court thought was a nuisance rather than some kind of an easement. Mr. Goff called the lake a wildcat impoundment because there was no authority from the state of Colorado. Well, we had the local water engineer testify at trial, and his view was it was fine with him if that lake stayed in existence, as long as he could come in and take off a few inches or a foot of water once a year to make up for the evaporative losses. He was fine with it. Speaking of the water in the lake, there were some changed circumstances in that the Hollands have been impounding water on their part of the lake. That's the deepest end, and that's near where the outlet is. We provided pictures to the trial court on remand, and said, hey, wait a minute, there's some water here, and there's pictures of watercraft on the plaintiff's properties. And therefore, based on the majority's opinion that basically said no water, no easements, well, wait a minute, now there's water. So maybe we have easements on that. That's another question. What happens if water comes back? Another question is what happens about the wintertime easements that the trial court found? Snowshoeing, cross-country skiing, those don't need water. Are those still easements that are valid? It's an unanswered question. Thank you very much for your attention this morning.
We appreciate the arguments of both counsel. The case stands submitted. We will issue a written opinion in due course. Counsel in this case are excused. As soon as the tables are cleared, counsel in our second case may set up. Our next case is Colorado Real Estate Commission versus Seitz. We're ready to proceed.
Good morning. My name is Jordan May. I'm a privately retained attorney with the law firm of Frascona, Joyner, Goodman, and Greenstein. I represent the respondent and appellant, I should say respondents and appellants, Mr. Eugene Seitz and Platinum Partners Realty. At its core, this case involves the parameters of agency discretion in the imposition of licensee discipline. There are other issues, of course, including issues of statutory interpretation, but the core issue is that issue, is these parameters. The case on point here is fortunately, a Colorado Real Estate Commission case. Colorado Real Estate Commission versus Hannigan, 947 Pacific 2nd, 933 Colorado Supreme Court, 1997. And in Hannigan, the Colorado Supreme Court gives us 3 touchstones that help us define these parameters. And they are where the discipline has no relation to the conduct, where the discipline is arbitrary or capricious, or where it's manifestly excessive in relation to the public need. The court also provides us some guidance, and specifically there's a quotation in the case where the court says, the relationship of the sanction to the conduct and to the public need provides the courts with an analytical grid on which to map agency discretion. And then, following that quotation, the Colorado Supreme Court walks through the legal aspects of that case as well as the factual aspects of that case, and reaches the conclusion in that particular case that public censure was an appropriate disciplinary lever for the Real Estate Commission to pull. Here, when we engage in that same analytical process, the first step, I believe, is to approach the statutory interpretation issues. And so what we are calling on the Court of Appeals to assist us with is the statutory interpretation of one statute, that's CRS 1261.113.1Q, which I refer to as undisclosed compensation, a secret or undisclosed compensation, and a rule, and that rule is E108. That is what we lovingly refer to as the markup rule. The Lucero case tells us, that's Lucero versus Department of Insurance, 942 Pacific 2nd, 1246, provides the guidance on which we examine the statutory interpretation at the agency level of the statute. And the Anderson case, that's the Anderson versus Longmont Toyota Inc., 102 Pacific 3rd, 323, tells us we look to the plain meaning of the statute. In this case, the statute provides that a broker may be disciplined for secret or undisclosed compensation, quote, for any acts for which a license is required under this Part 1, meaning brokerage. What we've seen in the last several years, we saw a case, McDonald, there's a previous case referred to as Seibel. What we've seen is an issue where the Court of Appeals is called upon to tell us, what the statute 1261.113.1 is a laundry list of conduct that entitles the Real Estate Commission to discipline a broker in Colorado. The several cases that we've seen over the last decades, including the McDonald case, which is the recent case, help us understand, is a broker to be disciplined while engaging only in brokerage conduct? That's meaning engaging as a broker? Or can the Real Estate Commission discipline a broker for conduct outside the brokerage context? In other words, in the McDonald case, the Court of Appeals was called upon to address the question of, can we discipline Mr. McDonald under 1261.113.1N, unworthiness or incompetency, if he is only acting as a broker or if he's engaged in extra brokerage conduct? In that case, the Court of Appeals said no. We can only discipline him under the statute if he is engaged in brokerage conduct. The Court of Appeals is called upon to answer the same exact question with regard to 1261.113.1Q in this case. The question is, can Mr. Seitz be disciplined where he is out in the world engaging in conduct outside the brokerage context?
Well, exactly what conduct is it that you contend is outside? I mean, you use the word brokerage conduct. I think the statute, you could
Sure.
say, for which a license is required.
Excellent question. In this case, there is no dispute that there is an affiliated maintenance company, what we refer to as Platinum Property Services, PPS for short. That company does not require a real estate license. It is outside the jurisdiction of the Colorado Real Estate Commission. It is traditionally an affiliated business. It's governed by RESPA. It's governed by Colorado state-level RESPA statutes. And the undisputed evidence in this case is that disclosure, the RESPA obligated disclosure, the disclosure obligated by Colorado state law under 1261.113.2 was made. And we see that over and over again. The record is replete with the disclosures, the written disclosures that the witnesses testified, yes, I signed this acknowledging the relationship between the brokerage firm and the non-brokerage affiliated maintenance company. And what we are talking about, to put a fine point on it, is disciplining Mr. Seitz and the brokerage firm for this maintenance company operation. In other words, the maintenance company was charging fees, providing coordination services to clients who had opted to use that company. The Real Estate Commission is contending that there is some sort of a secret profit that occurred there that permits them to discipline Mr. Seitz, even though the maintenance company is not, the operation of that maintenance company, its day-to-day operations, is not an act for which a license is required.
But a license is required for the rental services that Platinum performed, correct?
Absolutely.
And isn't your argument foreclosed by the factual determinations of the close nexus between how Platinum coordinated these services with the landlord clients? In other words, the PPS isn't just a stranger out there in the forest.
Absolutely not. It's an affiliated maintenance company that the clients of Platinum, the brokerage firm, had opted to use.
Okay, but do you dispute the factual finding, which I'm paraphrasing, that Platinum coordinated between and among the complaints, which I guess typically would come from the tenant, the landlord, and PPS?
Well, so I think what the order says, the facts are, as I understand it from the record, is that a maintenance request may come in from a tenant to Platinum, the brokerage firm. Platinum would then coordinate that maintenance request with the owner. So Platinum would say, okay, let's go review the management agreement, let's investigate whether or not this particular owner has opted in to use our affiliated
Mhm.
maintenance company. If it had, it would send the maintenance request over to the PPS, the maintenance company, at the owner's direction.
Well, why isn't that inextricably intertwined with the licensure requirement for a broker to act essentially as a landlord's agent?
Well, I think the reason is because we have a very carefully crafted legislative regime for compliance with exactly this type of business relationship, and that is the RESPA and the state-level RESPA statutes and rules. So by that I mean CRS 1261-113.2 and Rule E46. And so the way that works is this model is pervasive in Colorado. So for example, if a real estate broker has an interest in a title company, the real estate broker can say, hey, Mr. Seller, I'd like you to use my title company. It's over here. I'm providing the form disclosure for use of that title company. That disclosure, that form, is published by the Department of Housing and Urban Development, right? So we do not have a state-level form for that purpose. And that is the disclosure regime that is required, and that Mr. Seitz and Platinum followed. In other words, I think at some point in the record, there was a statement that we thought we were hyper-compliant. We thought we were going above and beyond. We had two separate disclosure statements that disclosed the relationship, the common ownership between the brokerage firm and the maintenance company, the fact that the owner did not need to use the maintenance company. They had an opt-in right. They were advised to go seek other services or investigate the possibility of those services being provided by other providers. These disclosures were all made in writing to the owners that then opted in. Does that answer your question?
Is it your position that and I hate to use the word secret profit, but let's just call it a markup. Is it your position that those disclosures expressly inform the landlords of the markup?
Well, yes. I mean, and I think that Administrative Law Judge Light reached the same conclusion, that there was no question that the owners received a disclosure of the fact that there could be a financial benefit in them opting to use PPS. The testimony, if you read the record, the testimony at trial made no sense. Mr. Circo, one of the witnesses, testified that he understood that there would be a benefit if he opted in to use PPS. He just wasn't clear about who it was going to. He thought it was going off to some third party that wasn't present. So what I read from the record is that the owners that opted into PPS unequivocally understood that there would be some benefit to Platinum and its owners by the use of PPS for maintenance purposes.
Did the disclosures specifically say the benefit would flow to Mr. Seitz, or only that the potential benefit would flow to Platinum?
It did not. It did say that the ownership was common, and that Platinum, the brokerage, could receive a benefit from the owner opting into PPS.
How is that an adequate disclosure then of the fact that Mr. Seitz would receive an indirect profit or benefit?
Two answers to that question, Judge. One is that the testimony at trial was that Mr. Seitz has never actually received a benefit other than some incidental tax benefits. At all times relevant to this case, there had been no distribution to PPS, to him from PPS. The other is that this model this is nothing special. This occurs every day in the state. And so, for example, in the example I just referenced, where a broker sends a seller to a title company that broker has an affiliated relationship with, there's no disclosure of a fee or of the money that the return on investment that the broker will receive from the seller's use of that title company. But here, the Real Estate Commission is saying that it's a revocation level event for a broker to engage in this and not disclose the precise amount of each, really the return on investment that Mr. Seitz is receiving. With that, I'll reserve the remainder of my balance for rebuttal. Thank you.
Good morning. May it please the court, Gina Canan, registration number 45071 for Appellee Colorado Real Estate Commission. I'd like to address two of appellant's contentions that were brought up in opposing counsel's remarks. First, I think, is the issue that appellants are collapsing the legal requirements to disclose an affiliated business relationship and the requirement to disclose markups. There's two separate requirements under the statutory and regulatory framework. One is disclose the affiliated business relationship. That's not at issue. It's governed by 1261.113.22a. But the violation at issue is to disclose compensation, including markups, for services performed by third parties or affiliated businesses. That requirement is governed by 1261.113.1q and Rule E108. The other thing that's at issue is the statutory interpretation of what in connection with means. That language comes from 113.1q. And I think, Judge Webb, you were kind of drilling down into, does in connection with mean in exchange for, or is it broader than that? And how the commission interpreted it was that because coordination and billing of these maintenance services was occurring as part of the package of Platinum's property management services, those markups were assessed and received in connection with acts that require a real estate broker's license, and that's the property management services.
Let me come back to the markup question for a minute.
Yeah.
Distinguishing Mr. Seitz from the company, Platinum, what undisclosed compensation did Platinum receive?
Well, it's undisputed that PPS was an affiliated business, and what that means is that Mr. Seitz was receiving compensation in the form of a return on investment. That's the only compensation that's permitted.
Well, excuse me, though. I was trying to distinguish, and you know, one of the claims that the respondents make is that there was never a careful distinction between what Mr. Seitz did versus what Platinum did. So my question attempts to distinguish between the two. Help me understand, what secret compensation did Platinum receive?
The final agency order is not very great at distinguishing between the two appellants, I agree. Platinum was the one that was assessing and receiving the markups. And if you'll notice, the final agency order only assessed fines against Platinum and Seitz. It didn't parse out, okay, there are two violations here against each person. It only assessed fines for basically one violation, without articulating whether it was Mr. Seitz or Platinum that it was assessing that violation under. Mr. Seitz is...
How should we on appeal deal with that ambiguity?
Well, it's clear that from the record that Mr. Seitz is the one that was receiving undisclosed compensation, and it's undisputed that PPS was an affiliated business, and that because he was receiving that undisclosed compensation and Platinum was assessing and receiving the markups, that he had an obligation to disclose those markups to Platinum clients. And the reason he had that obligation is because it was appellants that were contracting with property owners and representing that they had this preferred relationship with PPS, and property owners were going to benefit in the form of cheaper and faster maintenance, and PPS was going to perform the work. Under the contract, one of Platinum's duties was to coordinate maintenance on the property. They were specifically required to hire, supervise, and contract for all independent contractor labor. But what really ended up happening was that Platinum called PPS, and PPS called a third-party contractor. And the property owners ended up paying for this level of markups for the services that PPS was rendering without those markups ever being disclosed. It's undisputed that Mr. Seitz was receiving compensation under the plain language of the rule. He was therefore required to disclose the markups for the services that PPS was providing, because those markups were assessed and received through Platinum. I'd also like to discuss the penalties at issue briefly. Appellants make much of the commission setting aside the ALJ's recommendations regarding discipline. I believe that characterization ignores the statutory framework. It's the commission, not the ALJ, that has the subject matter expertise to determine the appropriate sanction upon review. The commission has a specific power to affirm, modify, or set aside the ALJ's recommendations. Also significant here is that the commission found 6 additional violations, 2 violations for each of 3 consumers harmed. The ALJ expressly decided against revocation on the basis that the security deposit incident had only occurred one time. That wasn't true anymore once the commission found additional violations. But even setting aside the violations for undisclosed markups, the commission was really concerned with the conduct underlying the security deposit issue. They focused on appellant's wrongful taking of Mr. Marshall's security deposit. They found it particularly egregious that Mr. Seitz never returned the security deposit to the tenant. And their finding of a violation for incompetent and unworthy practice that endangers the public was based on the security deposit issue. In this case, we have previous stipulations to discipline imposed for similar alleged violations and actual harm to 5 consumers. I want to compare that with one of the cases cited by appellants, which is Hickam. There were 3 violations at issue there: misrepresentation, failure to disclose, and unworthy and incompetent practice. For those 3 violations, the commission revoked his license, despite the fact that there was no prior disciplinary history and no public harm had occurred.
Now, you made and I apologize if it kind of slipped by me. You made a reference to 5 consumers being harmed. Is
Yes.
that the disciplinary history as opposed to this case?
No, that's all in this case, Your Honor. That's,
There are 3 landlords.
there's Mr. Circo, Mr. Irwin, and Mr. Stewart were the consumers who had undisclosed markups assessed
Right.
against them. And then the Goomans and Mr.
Okay.
Marshall were the parties that were harmed by the security deposit issue.
Okay.
In reviewing the discipline imposed here, this court should look at the whole record to determine whether the commission's action is supportable. And I'd also like to flag for the court the issue that appellants repeatedly refer to license revocation as permanent. Under our statutory scheme, license revocation is not permanent. In fact, appellants may reapply for licensure within a year under 1261-113-8. Of course, they must demonstrate that they are qualified and rehabilitated and that they are worthy of licensure, and that's warranted. But revocation is not a death sentence.
The record is a little unclear, but as best I could determine, the markups that these 3 landlords paid was about $600. Does that sound right?
That sounds about right.
How should we view that in terms of proportionality of license revocation?
I don't know that the monetary, I think the pattern and practice and course of conduct here was what the commission was really focused on as far as the duties that were owed to clients because of the broker relationship and the fact that instead of putting those clients' interests first, these markups were not disclosed, and as a result, these clients ended up paying more for property management services than they contractually knew about, basically. Some of the facts that the commission was looking at were the fact that these maintenance services were offered as part of its property management services. If you look at this violation alongside the false advertising violation, I think that really illuminates the course of conduct that the commission was looking at as a whole here. They were advertising that they had this preferred relationship and that as part of your package of property management services, you're going to get these maintenance services included and you're going to get them faster and you're going to get them cheaper. And appellants didn't appeal the false advertising violation. And I think it's really important to look at the discipline imposed in the context of this overall course of conduct and this pattern, including the previous stipulation for discipline regarding kind of similar allegations, including an E-108 violation. And we understand that that was a no-admit stipulation, but the commission was looking at this historical pattern and practice of complaints being received in 2010 and 11. They received 11 complaints. And then again, in 2013 and 14, they received these complaints. And in considering revocation, they really were looking at the entire licensee's history, the ability to be regulated, the ability to read the rules and understand and comply with them, and the spirit of them, including recognizing that, I believe that's why the additional finding was made regarding the fiduciary duty. They wanted to recognize here that appellants owed, as real estate brokers, specific duties of loyalty and fidelity to clients to put their interests first and disclose all the charges that they would be paying.
In counsel's argument said this is a widespread practice. Is there any evidence in the record that is a common practice for real estate brokerage firms that represent, landlords as opposed to buyers and sellers to have affiliated maintenance companies?
That is not in the record, Your Honor. It's news to me as well.
Enough said.
If Your Honors have no further questions, I appreciate your time this morning.
Thank you. To get back to my original point from the outset, in determining whether or not agency action in this particular case is manifestly excessive, the way we look at that, the way we address that question is we look at the sanction, we look at the conduct, and we look at the needs of the public. In this particular case, the sanction is revocation and a very high fine. It's revocation of Mr. Seitz' license, it's revocation of Platinum, the brokerage firm, which has a number of employees, both licensed brokers and non-licensed brokers, and very high fines. I think it was $28,500 with the state's markup, in addition to public censure. And those effects, right, the effects of the fine payment, public censure, that is a permanent effect. That will never go away. Those sanctions, when compared to the conduct, I think the court is right that the total markups and evidence were roughly $600. In addition to a one-off security deposit dispute that involved a $2,200 security deposit that Platinum believed it had the contractual right to utilize to pay itself a early termination fee. The testimony, the undisputed testimony is that Mr. Seitz changed this policy. He mitigated it immediately. This was only ever a one-off. In fact, Judge Light found in her order, which is Exhibit 47 on page 21, the ALJ does not necessarily believe that Mr. Seitz intended the result that happened here or could have foreseen this result when he developed Platinum's policies, specifically with regard to the $2,200 security deposit incident. In addition, the landlord and tenant both disputed. They both claimed full entitlement to that security deposit. And so there was a dispute where essentially the property manager was stuck in the middle. But we look at here the sanction, we look at the conduct, and we look at the needs of the public. And the question is, does the public need Mr. Seitz's license to be revoked?
Let me come back to the security deposit for a
Yes.
second, because the assertion was made that the tenant never got the security deposit back. Is that correct?
I think that's correct. As I understood it, the landlord in that particular case said, my property was damaged, and I am fully entitled to the security deposit.
Now, is that in the record that the landlord made a claim against the security deposit?
I believe so. I believe that that was his contention.
Okay.
Was the money then, the security deposit funds paid over to the landlord?
Not physically. They had been credited to his trust
I
account.
understand that, but after the complaint is filed, was the money then paid over to the landlord? Because if your client no longer represented him, then they had no claim to hold that money. Did they turn it over to the landlord and let him and the tenant fight it out?
No, it was simply a credit, nothing more. So as I understand it, the mechanism was to move the funds from the security deposit trust to the rental income trust as a credit to the landlord. And then a week or 10 days later, the software charge, there was, I think the evidence was $2,700 more or less in the landlord's trust account. The software charged the $2,200. It just was happenstance that the security deposit happened to match the precise amount of the early termination fee. The dollars aren't fungible, so there was a larger amount in the landlord's trust. That money, the $2,200 charge was imposed. Mr. Seitz does not, he takes responsibility for the fact that the software imposed the charge, and then the landlord was later remitted the remainder of the balance in his trust account. It was $500 some odd.
Thank you. I think your time's exhausted.
Of course, thank you.
We appreciate the arguments of both counsel. Counsel are excused. We will issue a written opinion in due course. This completes this morning's docket, and the bailiff may announce the recess.